Hi, everyone. Thanks so much for joining us at our panel discussion about POPI. I know we've had, hi, Yapi. Yapi's just said hello to us on the chat. I know that there have been a lot of questions about POPI and the POPI Act in social media groups and that kind of thing. So we thought, what a great way to address all these questions that we're currently getting or that we're seeing on social media by having a webinar with our three experts on the subject. So I'm going to share my screen with the webinar presentation on it. Leigh-Anne, can you see the presentation? Okay, perfect.
I can, yes. Thanks, Daniela.
Okay, fantastic. Okay, great. So the topic we're going to be discussing today is how the POPI Act affects community schemes. And as I said, this is a widely questioned, sorry. There we go. Yeah, as I said, we're getting a lot of questions about this. So let me start by introducing you to our host today. So Willie Roos is the CEO of Stratafin. He has practiced as a property attorney for over 20 years. He has been involved in the sectional title management for over 8 years. Billy started Stratafin in 2014 with the goal of assisting bodies corporates with their funding without catching them in a debt trap. Stratafin strives to be a fair and equitable money provider for the sectional title industry. Willie built up Stratafin from its inception to today, where it has debtors under management of over 300 million rand. Stratafin has also partnered with Medu Capital, and the PRC has invested with a 45% ownership. On to our speakers. So firstly, we've got Zerlinda van der Merwe. She's the co-founder and director of TVDM Consultants. Zerlinda is a specialist community schemes consultant offering the services of legal advice in the form of consultations and legal opinions, meeting and CSOS attendance, governance documentation review and amendments, as well as being a professional trustee in her spare time. Zerlinda's background is that she is an owner and resident in an HOA and an investor owner in sectional title schemes, a previous managing agent and a practicing attorney. Zerlinda lives and breathes community scheme living and absolutely loves it. Second of our speakers is Leigh-Anne Harrison. She is a portfolio manager at RPA Property Administrators. Leigh-Anne holds an LLB degree from the University of Stellenbosch. Her professional career commenced in 2014 when she was admitted as an attorney of the High Court of South Africa. She was a practicing attorney before she joined Trafalgar Property Management in 2017 as a sectional title property manager. Thereafter, she joined Pam Golding as a property manager, where she focused on the management of homeowner associations and is now employed by RPA Property Administrators in the similar role, focusing on commercial and residential community schemes. And third is Rudi Jack Heerschop. He is the director of Schüler Heerschop Pienaar Attorneys. Rudi holds an LLB degree from the University of Johannesburg and is the director of Schüler Heerschop Pienaar Attorneys. Rudi is also the head of their community scheme department, which specializes in all matters relating to community schemes, from registration to collections, scheme governance, and dispute resolutions. In addition, and in honoring their commitment to community upliftment and education, he is actively involved in community advisory services relating to community schemes. His firm is an affiliate member of the National Association of Managing Agents, or NAMA, and Rudi is one of their preferred speakers at the training, conferences, and often provides seminars, articles, and opinion pieces which guide and inform their clients and the community scheme industry. So let me hand over to Willie. He will continue.
Thank you, Daniela. Daniela is the marketing manager at marketing and sales manager at Stratafin. So for any marketing and sales advice, you guys can contact her as well. I think we're going to start with what is POPI. Rudi, I'm going to draw you right into the conversation here, and let's have a look at what POPI is and how that is going to affect everybody on this discussion here today.
Thank you, guys. Thank you for having me. Just some housekeeping, Daniela. I think you showing the presenter's view.
Sorry, so let me fix that. There we go.
Yes. Okay, so I thought that we're going to start off this discussion just to show everybody how POPI is applicable. And I decided that let's refer to the Act and actually see what the Act says. So in terms of the Act, POPI Act applies to any person or entity, whether it's a public or a private entity domiciled within South Africa, that one processes two personal information by entering such personal information and the third requirement into a record. So when we look at process, it's any operational activity or any set of operations, whether or not by automatic means concerning personal information, including the collection, receipt, recording, organization, collation, storage, updating, and so forth of information. So you can see that most of the industry players, and especially managing agents and community schemes, they are indeed processing personal information. So if we go look at the second part, what is personal information? Because we see a lot of people stating and asking why that they need to be POPI compliant. And it's because of that definition. And let's quickly look at what the Act defines personal information. I'm not going to go through everything, but I just want to highlight some of the things so that you can see what the Act actually refers to as personal information. So under A, it is information relating to race, gender, sex, pregnancy, marital status, national, ethnic, or social origin, color, sexual orientation, age, physical or mental health, well-being, disability, religion, conscious belief, culture, language, and birth of that person. So just by looking at that, most of the members fall within that. Then the second one under C is any identifying number, symbol, email address, physical address, telephone number, location information, online identifier, or any other particular assignment to that person. So it's clear that community schemes, and that's an obligation placed in terms of the Companies Act and the Sexual Title Schemes Management Act, that a community scheme and an HRA governed by the Companies Act must have all of these information. So what we've established is that the community schemes, they process information. Secondly, it is personal information that's being processed. And if we can go to the third slide, which is what is the record as defined in the Act. It means recorded information regardless of any form or medium, including any of the following: writing on any material, information produced, recorded, or stored by means of any type, tape recorder, computer equipment, whether hardware or software, both, and so forth. So it's clear that you can see the Act actually went further than just saying 1, 2, 3. It's a very wide definition of record. So if you are one of those schemes that you actually have a black folder with everybody's names written down with a pen on a piece of paper, you still need to comply with the Act, because this is what the Act is saying. So it is a very wide definition, and I can assure everybody that's sitting here, community schemes must apply with the POPI regulations and the principles reported there.
Just out of this, Rudi, I see that the Act says that the entity must be domiciled in South Africa. So does that mean that POPI will not be applicable to international companies that are not domiciled in South Africa, just out of interest sake?
Yeah, so if it's an outside company, not domiciled here, but they're actually processing personal information in South Africa regarding South Africans, then they must be POPI compliant. Okay. But what they say is if there's a auto forwarding system that is in South Africa regarding personal information of people in the outside our borders, it comes in just for forwarding purposes, then you don't have to comply. But a lot of the companies, the listed companies that's based in Mauritius for tax purposes, but the information pertains to South Africa, they must be compliant.
Okay, and then in the definitions, it also refers to biometrics. I mean, there's a lot of questions and we will deal with them later on, but I'll see that biometric information is specifically included in there.
Yes, yes, and that's also sensitive information. So it's treated a little bit differently, and there's high standards on biometric information as well.
But there's quite a few.
Yeah, what is also interesting, yeah, and it's not per se applicable to community schemes, but look at number G, the views or opinions of another individual about the person. So if I've got certain views of you, buddy, and that is information, personal information that you said to me, that constitutes personal information as well, just your views. So this is how wide the legislator went. So even your opinions, it forms part of personal information. So yeah.
Sure. Yeah, that's very wide.
Yes.
Leigh-Anne, to whom does POPI apply?
Thanks, Rudi, and thanks for having me this morning. I'm very happy to be working with yourselves, Rudi and Zerlinda. So what I do is, whenever I talk to anybody about the Act, I like to unpack this sentence, that POPI applies to any person that processes personal information. So that can be broken down into three parts: person, processing, and personal information. Now, Rudi has spoken on processing and of the personal information. So I'd like to just touch on, what is a person? Under the definition section of the Act, person relates to any natural or juristic person. Now, natural meaning an individual like you and me, and juristic person being an association of people, including a company, partnership, NGO, closed corporation, or otherwise. This also includes community schemes, whether you body corporates, HOAs, and share block schemes. Thus, the Act does apply to body corporates, community schemes, homeowners associations, and the like.
And what's the type of information that wants to be protected or should be protected under the Act?
So for the purposes of community schemes, if I refer to a simple example, like a member of the scheme, an owner, the scheme collects the information for the purposes of sending them statements every month, communicating with them. So they would need their contact information, physical address, domicilium, postal address, their contact details, date of birth, marital status relating to the unit if they're married in other community or property. So that's the kind of information that a body corporate or community scheme processes, and that is why the Act is applicable to them.
Okay, I also see that you are referring to the constitutional right of privacy of individuals. Can you explain to us a bit about that?
So a lot of questions came through is that, what is the purpose of Papia now? Why is there all red tape that has come about? So prior to POPI, there was always this right that every individual had, and that is the right to privacy. Papia was ultimately enacted to promote and protect one's right to privacy and the right to protection of their information. What the legislators did is, POPI came into commencement on the 1st of July last year. They gave everybody a grace period of 1 year to come into compliance, with parties now having until the 30th of June this year to bring themselves into compliance. One of the further questions I got is whether you want to obtain a copy of the Act. I've added the link for the government website where they literally list every section of the Act and the provisions thereof. I actually have my own copy that I keep with me at all times for reference purposes. And I use it whenever I'm stuck, or I can refer to a section in the Act if I get a question. Further question we got from the participants is, what is the difference between Papia and Pyre? Now, Papia is the protection of personal information, and Pyre relates to the promotion of access to information. Both acts were enacted to promote sections in the Constitution, Papia relating to Section 14, the right to privacy, and Pyre relating to Section 32(1) of the Constitution, which states that everyone has the right to access to information of any information held by another person that they require for the exercising of their rights. And again, another question, why is there more red tape? And I revert back to the purpose of the Act is for the protection of information, giving effect to one's individual rights to privacy in terms of the Constitution. This comes into play, in the past, there's been massive data breaches with banks and other service providers. So this legislation ultimately is trying to ensure that doesn't take place in the future.
So how long must this information be kept?
So it really depends on the natural juristic person that is holding the information. I know with community schemes, generally it states that, once an owner is no longer an owner in a scheme, the reason you kept the information, there's no longer a purpose for that information and it needs to be destroyed. The act, the legislation applicable to managing agents and body corporates is that generally after 5 years, then you would then destroy the information that you have kept. And again, the act doesn't state how you must destroy it, but just that it's being destroyed in a safe manner.
Can I just use a practical example? We are involved in this particular scheme where we have assisted them financially, and this scheme is under administration. And when the scheme was placed under administration, there was a dispute. Initially under administration, there was a dispute as to the amount owing to the council. Clearance certificates were issued, but an amount of 74,000 Rand was kept by the attorneys in trust pending the finalization of this dispute to determine who will pay this. Was it going to be, or what amount will be paid? So must the owner that at that stage, the owner of the property that was the owner, will he pay that 74,000 Rand, or if the council agreed to a lower amount, what should then be paid by him? So the attorneys kept this money in trust. Now, 6 years or 7 years later, it was in 2014 that amount was kept, and now 7 years later, we finally resolved the issues with the city of Joburg, and we know what is owing, and it's not 2.4 million that was owing, but actually 8.5 million that was owed by the scheme. And we now need to go back to this previous owner, but now all this information has been destroyed. Can we now go and obtain information from the credit bureaus, or how do we get this person now to get payment from him or proceed with this process?
Look, I think I think this is an answer that Rudi can provide. But from my point of view, it always goes about, the purpose of storage of that information. Yes, at the time, they may have thought that they don't require to keep the information of this owner any longer, they've destroyed it. So obtaining it from another service provider would be permissible because you are doing it for a specific purpose. Okay. But I think this is a good question for Rudi to answer.
Yes, just on the point of retention of data. So what the Act says, if the reason for the processing has been terminated, then you must de-identify the person and or in brackets get rid of the personal information. But with regards to the question of 7 years later, look, when we look at the personal details, you will be able to find the person through the databases of the deeds office, but you'll find a name and perhaps an ID number. That's it. I think the practical answer to this is appoint a tracer to do the necessary searches. In time, we will see, and I know TransUnion and Experian, they're busy beefing up their POPI compliance and their privacy policies. So I don't know what it's going to be like in the future come 1 July, because the simple thing is we can now do a search from this side to try and obtain the person's details, but I don't know what the future will hold for that, whether or not the companies like TransUnion, Searchworks, whether they're going to be more strict in providing these personal information. Yeah. Because the thing is, if you look, and this is also technically now, if you look at section 11 of the POPI Act, where it says when you process personal information, one of the statements is if it's in a legitimate interest. Now that will fall within a legitimate interest of processing this person's information, because you need to find him and you need to institute action against him. I don't think it is the intention of the legislator to say you must now play this cat and mouse game with this person and we're going to withhold this information because of POPI. I don't think it will be applicable. So I think we will be able to trace them and perhaps just get their details from the internet. Thanks. Or service providers.
Thank you. Leigh-Anne, who will be responsible for ensuring compliance with Papia?
the Act states that any person who processes personal information is then responsible in terms of its provisions for the compliance with the Act. So it would be, in the case of body corporates, your body corporate or your HOA or any other scheme that processes information. It seems it's a bit of a loaded answer, because now you're looking for the actual person who is responsible for compliance. And in that way, it's whoever the body corporate appoints as the information officer. The Act states that information officer is ultimately the one who has to ensure compliance with the provisions of the Act.
Before the participants joined, we actually had a long discussion about this, and Rudi, you were giving your views as to who that should be, because I think that's also a question that's coming up a lot. Must it be a trustee? Can it be the managing agent, and so forth? So that was a question that we've seen a lot of. What is your views in that regard?
Yes, it is a very interesting question. So when we look at POPI, you must also consider Pyre, because there's reference between the two. Now, when the legislator drafted Pyre or POPI, they decided on there needs to be a responsible person. They started looking for this person, and then they realized, okay, Pyre has an information officer, because POPI and Pyre is polar opposites of the same point. They said, all right, let us make the information officer of Pyre the same person as the information officer of POPI. So you need to go look at the definitions. So if you look at the definitions, and I'm going to, for purposes of the answer, I'll just refer to the community scheme as a juristic entity. They say it needs to be the head, i.e. for community schemes, it's the chairperson, alternatively a person duly authorized by the head. That is the long and the short of what the law says. Now, in mid-April, we saw the information regulator publish guidance notes. Now, we don't know whether the guidance notes is law. We don't know how the court or the regulator will interpret these guidance notes, but they go a step further in saying that the information officer is the head, alternatively somebody duly authorized, and they define the duly authorized as an employee of the juristic person who answers to the head. So one would then automatically assume that that is a person in management and not just the cleaner. So I don't know whether that is correct, because the issue that we have is there's a lot of time, and a lot of instances, there's companies and juristic persons with no employees and just shareholders. So
if I understand what you're saying correctly, it means that the managing agent can't be the officer, no, because they're not the head, nor are they an employee of the body corporate.
Yes, if you read the Act, and this is the issue that I have with the Act, or with the guidance note, the Act clearly states somebody authorized by the head. But now the guidance note comes in and it says, well, that person can only be an employee. So I don't know what is going to be stated in the regulations to be published soon, but that is contradictory to one another, because it's somebody authorized, and now you dictate to me, well, you can only authorize that person. As it stands now, I cannot see that the managing agent will be precluded going forward. But for now, there's uncertainty on this point. I'm personally of the view that there's nobody better than the actual managing agent to adopt the role. But if it's going to come down to that they're not allowed to do it because the regulator excludes them, then they can still perform the duties in terms of the Act. The duties can be outsourced, but you must understand that accountability cannot be outsourced. So even if the scheme says the managing agent will perform the functions and ensure compliance with Papia and Pyre, if there's a breach, the regulator will always knock on the door of the actual legal entity and not the outsourced person. So yeah, so it's difficult at this stage to guide, but for now it seems as if the managing agents are excluded from the information officer. And I just want to add this, Rudi. So 2 nights ago, the portal went open for the registration of information officer. So with some of my commercial clients, and especially with listed companies with a lot of affiliated companies below them, what they did is, and what we said is, we'll get one information officer for the whole group. As we started to submit the data of the first company of this information officer, with the second company, the portal doesn't allow the information officer to be the same information for a different entity. So that's they need to change that up as well. So it's a difficult thing, because now the portal also, when interpreting that stock, or then it would suggest that you can only be an information officer for one entity, which is not the case. The Act doesn't say that, the guidance doesn't
So
say
that will in any event create a problem for managing agents. So if they would want to even register, they're going to have a problem that they're not going to be allowed to do that.
Yes, of course.
Yeah. Sure. Okay. And then the final responsibility will then always revert back to the chairman. I mean, because he's the head.
Yes.
Correct.
Sorry for the chairman.
We're going to have instances where nobody wants to be chairman, and then we're going to have to say, well, one of the trustees, and we're going to sit with schemes with no executive committee, and then it's going to be up to the default position. There might be the administrator or the executive managing agent. That's how I see the executive managing agent coming in. But the problem is the Act does not, or the guidance note does not make provisions for that. So we're going to have to wait and see how the regulator interprets this, especially with regards to community schemes.
Okay, then part of that, the discussion that we also had earlier on, before the other people joined us, was the moment that the managing agent is registered. Would the managing agent be at risk if it is possible that the managing agent can be registered? Where does the risk lie in respect?
Yeah, so this is also the thing. If you look at the accountability in terms of the Act, it refers to the head. So the accountability will always go to the CEO or the head of the entity. However, with the guidance notes and the regulation published, it would seem that the information officer might be held liable for infringements. So they refer to a 3,000 rand fine at this stage per infringement. So I don't know how they're going to tie that in, whether they're going to say this is for the information officer and this is for the actual entity. So at this stage, we don't know. But ultimately, the accountability is the defaulting position, which is the head of the institution.
So there would be risk for the managing agent if they are then.
Yeah.
All right. Leigh-Anne, another question that we got was regarding the size of the entities. Applicable to everybody or just applicable to the big schemes?
Unfortunately, not really. There's no distinction in the Act. Any party, big or small, that processes personal information is bound by the provisions prescribed by the Act. Look,
so even a scheme of 2 duets will have the same responsibilities?
Yes, because both of them are processing information on a similar basis. For the purposes of the scheme, they have the members' information, they utilize it for the purposes of submitting statements every month, communication with the owners, and the like. So there's no distinction between big or small and what they do, because ultimately a scheme, whether 100 units or 2, do the same thing. They process information on a daily basis.
Another question that we got was in respect of rentals, those owners that are renting out properties in schemes. Are they also liable, or must they comply with the law as well?
Look, if they're processing personal information, i.e. the details of their tenant, then that Papia is applicable to them. They are bound by the provisions that the Act prescribes in terms of protection of the information that they are collecting. If they ever share it for whatever purpose, how they retain it or keep it safe, and then ultimately destroy the information once they are no longer a tenant of their property.
Well, on this note, I just want to add that there's no exemptions at this stage. We really anticipated when the draft guidance notes came out and the actual guidance note that there will be certain exemptions. Because the problem is, if we interpret the Act in a strict manner, if you attend to a vendor on a street and they have a card machine or a zapper, they must have they must be POPI compliant. Because the problem is, as soon as I pay with my card, on their bank statements, there will be information that can be tied to me. So they need to register an information officer. They need to have the policy documents in place. So this is the state of the affairs as we speak. So hopefully the legislator will develop and the regulator will develop further rules for exemptions, and we really hope that there will be certain exemptions. But at this stage, there's no exemptions.
Okay, I think that takes care of question 12 as well, that we got quite a bit of. So no exemptions at this stage, and all the information that is in the description of what personal information is at this stage is then falls under POPI and must be complied with.
Yes.
Zerlinda, can I draw you a bit in here? We had some questions. Can the managing agent be held liable for anything if the body corporate trustees refuse to sign contracts with POPI clauses or refuse to comply with POPI law, Papia?
So when we were prepping for this, and Willie and Daniela, thank you so much for the opportunity of involving us as well. Leigh-Anne's most certainly the expert for us, as well as Rudi in his own right with his own firm. So, you know, the ones that are non-POPI related is most certainly something that I can deal with. But whenever the question comes up with managing agents, I always want to pounce on it, because I've just seen too many comments and questions from trustees and from owners to say that surely the managing agent should do this. Surely we pay the managing agent to do it. And there was a question posted on the Q&A or the panel earlier to say that surely if, as Rudi mentions, you know, this does lend to involve the managing agent later with an amendment, you know, surely the managing agent needs to protect itself, it needs to charge the additional fees and all those fun things. And I definitely agree with that. I don't believe that it's something the managing agent should be responsible for. And I don't believe it's something the managing agent should not be able to charge for if they do become responsible for it. I can imagine that the insurance risk is going to be incredibly high, and they would need to be able to recuperate those types of charges. So at the moment, until such time as the managing agent is entitled to become the information officer, the managing agent can't be held liable if the body corporate does refuse to sign any contracts. But again, in terms of a management agreement, the managing agent very often puts themselves forward as an advisor or offers guidance to the body corporates. And unfortunately, you know, it does fall on the managing agent to ensure that the trustees at least are aware that there's compliance that is required. So a lot of our managing agent clients are approaching us to say, can you at least have a trustee training webinar with our clients to let them know what needs to be done, and more importantly, let them know what will happen to them if they don't comply. And that's basically us having done our job. And it sounds terrible for a managing agent to say, right, wash my hands clean, that's all I'm doing. But until such time as they're liable in terms of the legislation, that's really all they can do. So in summary, no, at this point, they can't be held liable.
Okay, awesome. What should the homeowners who lease his property, well, I think we've discussed that. Must they comply with POPI, and how is it regulated to those homeowners? I think it's also one of the things that you got asked quite a bit.
Yeah. So in terms of the legislation, it doesn't apply to the processing of personal information in the course of a purely personal or household activity. But for example, and I think it was a question on the chat function that popped up as well that I saw, you know, what happens if you use a rental company to do that? The rental company would obviously need to be compliant the same way that a managing agent has to have its own POPI manual and Pyre manual in place. The rental company would need to do so as well. And then I think Leigh-Anne can comment as to, you know, whether or not the landlord is a CC or a trust or a company, what the compliance requirements are there, but not from the normal course of, you know, a natural person leasing out their properties. But again, one should always be very cautious in the application of POPI and Pyre there. But perhaps, Leigh-Anne, you can just jump in to add there where I might have left off.
Yes, so under this question 16, I'll highlight further, you know, once you establish that Papia is applicable to you. What next? You know, how do you comply then with the Act? And the Act then prescribes 8 conditions or principles that you must follow when processing personal information, which I'll then touch on in the next few slides.
Okay, but you can go ahead. I mean, let's have a look at them. I mean, they're applicable here, so we'll come back to the other questions.
Yes, so on PMR 27, I do touch on this under number, you can go to the next slide. Under number 2, I do touch on this on PMR 27. So now that we've established that Papia is applicable to the body corporate, the body corporate now has to comply with these 8 conditions or principles when processing personal information. I'm just going to work through them, and under each of them, I'll just highlight the questions that I received and answer them as I go. So regarding accountability, you know, a person that processes in personal information, when they do so, they remain accountable and responsible for the information, even when they pass it on to a third party. Now, if I look in the case of a body corporate, every year you get your annual financial statements audited, and information is passed on to the auditor for those purposes. So whenever you are passing information on to another party, even though it's being transferred or sent through, you still remain accountable for what you have shared. And same goes for Facebook and WhatsApp groups, which we'll touch on further on down the line. Sorry.
Okay.
My apologies, I just got my receptionist giving me a heads up on something. So on WhatsApp and Facebook groups, you know, we are permitted to have these in terms of Papia. But the one thing that must be noted that if myself, Zerlinda, and Rudi are in a group and there's information shared between the 3 of us, you know, I can't just share the information freely thereafter because we created it for a purpose. Let's say we're 3 trustees in a scheme. When we share the information thereafter, we're accountable to whatever information we have processed. So it's important that when we share the information, we know that once we send it out there, we will be accountable to the other parties who gave the information to us. It's very important. It creates this positive duty in law when sharing information. The second principle, lawfulness and consent. I got a lot of questions on this, and what I'd like to mention, and it's quite funny. Rudi's brother Dylan was the one that really helped me understand this particular principle, and I generally revert back to this quite a lot when it comes to questions I receive. So whenever you process information, you can only do so where you've got a lawful basis, where there is something that is empowering you to process the information. Now, in the context of community schemes under body corporates, you've got the STSMA, you've got the STA, the CSOS Act, and for your HOAs, you have your constitution or your memorandum of incorporation. So one of the questions I got was, is consent required when information relating to an owner is required or requested? Now, if the law, you always look at, is there a lawful basis that empowers you to process the information, then no consent is required. So for instance, if a third party like Stratafin is requesting information of the owners because they require same for the funding process they're busy with, then the STSMA allows the body corporate to hand the information over to Stratafin for those purposes. That's your lawful basis. The Act is empowering you to do so. Same with the question regarding, are owners or residents entitled to CCTV locations within a scheme? And the question is yes, because owners are entitled to information regarding a scheme in terms of the STSMA as well. If I look at PMR 27 and its effect, or vice versa on Papia, PMR 27 allows for owners to request information of the scheme. Now, yes, a body corporate or managing agent must still comply with PMR 27, irrespective of Papia. PMR 27 allows for the processing of personal information, and one cannot hide behind the blanket protection of Papia because PMR 27 is your lawful basis for providing information to somebody. I'll give an example. I'm Unit 1 and Unit 3 above me has a bath leak. And I need the information of Unit 3 so that I can sort out the leak, deal with the damage, and the managing agent may come to me and say, unfortunately, in terms of POPI, I'm not permitted to give you the information. Now, hold on, PMR 27 empowers the managing agent to do so. Thus, you are required to still process the information and share it, even though Papia is legislation that governs protection of information. So whenever I'm asked, you know, can I share information? Can I send it to somebody? I always tell the clients, look at what your lawful basis is. What is empowering you to process the information? I hope that answers those questions.
Zerlinda, I see you shaking your head as well. You want to add something there?
I wanted to add, because, you know, before the mad rush to get compliant, as we've been experiencing the last 2 or 3 months, you know, managing agents and trustees have been referencing POPI many, many times when a particular difficult, or whatever you want to call it, owner requests for the owner's information. And, you know, technically speaking, there was never a requirement of the managing agent or trustee to say, well, why do you want it? If it's an owner, they're entitled to the information. And there was also never a requirement for the managing agent to get the consent of the trustees in order to do it. And there's, you know, always been a deadline for that as well. And what we've been advising managing agents and trustees, at least to protect themselves, is to say, well, if somebody's going to request any type of record, contact details, what you know, whatever it might be, let them do so in writing, and let them state the purpose for which they're going to be using it. So if an owner says, I want everybody's contact information because you're a useless managing agent and I want to remove you, or I don't like your face as the chairperson, I want to make sure that you're, you know, kicked off and your property gets sold, and whatever else the reasons are for getting owners' contact information, the requirement is that if that person, that owner, does not use that information for that purpose, they'd be in breach of POPI, not the body corporate, not the managing agent, not the trustees. And it at least protects the managing agent and the trustees to say, look, they said they were going to use it for this purpose, but instead they're a naughty estate agent and they're now trying to contact us all to sell our apartments or whatever it might be. So don't say no, but rather protect yourself in the way in which the request comes through, the way in which the request is dealt with. And of course, if somebody asks for certain information that is not listed in PMR 27, you know, you could have a different argument, but if you're asking for it, you have to give it.
Yeah. And then, you know, the other side of the coin is when an agent asks you for information, or the body corporate or the managing agent, where's your lawful basis? You don't have one, because in terms of the STSMA, you can only provide information to owners requesting it, not agents. So then there you would say to them, unfortunately, PMR 27 doesn't allow me to do so, nor does Papia.
Okay, perfect.
Cool.
We were dealing with those 8 conditions,
yes.
Leigh-Anne.
Yeah.
So you were, I think, at purpose, eh?
Yeah, purpose is next, and it also stems from what Zerlinda was saying. Whenever information is collected, it must be for a specific purpose. You know, for purposes of a community scheme or a body corporate, they collect information so that the scheme can run on a daily basis. As per the STSMA, there are requirements that a scheme be run in a certain manner. There are processes and procedures that must be followed by the managing agent or on behalf of the body corporate. And one question I did get was, has Papia now provided for information that may not be included in an AGM notice? And my answer was no, because your lawful basis for the provision or submission of AGM pack is the STSMA. The STSMA provides for all the information that must be included in an AGM notice. So whenever looking at what you can't and cannot include, you always revert back to your lawful basis, being the Sectional Title Schemes Management Act. The next item, number 4, further processing limitation. So once the purpose for which you have processed the information is achieved, the information then cannot be retained. So for instance, an owner is no longer an owner in the scheme. The information isn't required to be kept by the body corporate / managing agent. It has to be destroyed. Next,
Leigh-Anne, if I can just interrupt you,
yeah,
and just for the purposes of managing agents,
yes.
and I've been advising them specifically on this point, because the Act states that it cautions the responsible party against secondary processing of information. Now, we all know that most managing agents, or some of the managing agents, they have got 3 departments, one the managing agent, one the rental department, and one the sales department. So the managing agent actually gets the information or holds the information of the owners based on a contract. So technically speaking, you will be then entitled to hold this information because of you complying with your agreement with the community scheme. Now, what happens in practice is, this is an investor, when you have the information, that that person is an investor, but the rental portfolio is somewhere else. So what managing agents like to do is then contact this person and say, well, we also do rentals, or if you want a sale. Now, this is just a cautionary note, because you in one company and you have that personal information, don't be misguided that you can just use the information. You need to go back to the purpose. If you have that purpose based on an agreement with the community scheme for that purpose, the information must be held for that specific purpose. The Act does not allow for secondary processing of that information. So this is just a cautionary note. And
so you will have to build a Chinese wall basically between the different departments to ensure that. Okay.
That's exactly that.
Perfect.
Thanks, Rudi. The next one regarding information quality. There is an onus on a person to take reasonable steps to ensure that personal information records that are kept are accurate, up to date, and complete. One of the questions we got was, if an owner sends a request for the details to be updated, must they now complete a further form? And the answer is no. This condition creates a positive duty for a managing agent or body corporate to update information when received from an owner. There's a duty to do so if they receive a request to do so. There's no further documents that an owner has to complete in this instance. The next condition being openness. It's all about transparency. So a person, when processing information, they just need to inform the other party of how they intend using the information and processing it. And this then also relates to purpose. You're always going to have a purpose for the information you are protecting, and be transparent about that to the person that you get the information from.
Leigh-Anne, I'm seeing on the questions that we are getting, that homeowners, this question about homeowners association, and obviously private management rule 27 is not applicable to them. How is the information going to be handled by a homeowners association differently from the way that it will be dealt with by a sectional title scheme?
I think Zerlinda is in a better position to answer this because we spoke about this last night in another webinar we attended.
So,
okay.
When it comes to homeowners associations, obviously you'd need to see whether or not it's a common law association governed by its constitution and rules, or if it's a non-profit company governed by the memorandum of incorporation. And interestingly, in our review of these types of governance documents, there's very little that is actually open to members, and it's not very often that, like in terms of prescribed management rule 27, a person other than an owner actually has access to these records. So there's a lot more security, in inverted commas, for a homeowners association when it comes to this type of records, and one can really only access what is in terms of that governance documents. But the same process would need to apply. So exactly the same as in prescribed management rule 27, if there is a written request for it, if the documents that are requested are listed as documents that are available, the trustees or the directors or the managing agent again can ask what is the purpose for the request. And then, of course, process it that way. And the keeping of the information, the processing of the information, the security, the storage, the destruction is exactly the same in a body corporate or a homeowners association as it would be in a body corporate. The question that we received yesterday evening that Leigh-Anne spoke about was what the participant called a loosely formed association. I'm assuming it was a common law association with the constitution, saying that surely a POPI and Pyre can't apply to this association where it doesn't have all the stringent requirements of the Sectional Title Scheme Management Act. But unfortunately, the answer is that it has to comply exactly the same, irrespective of the nature of the HA or the size of the HA.
Yes, well, on that point as well, if it's HI governed by the Companies Act as well, you must have regard to section 24 to section 26, which also entitles certain members to certain information. So it's quite similar to the Sectional Title Schemes Management Act. It differs on a few points, but it's similar. So your reference will be the Companies Act, in failing which then the governing documents as well.
Yeah.
Perfect. Okay, Leigh-Anne, let's just deal with then, I think it's openness and security and participation.
On security, I think it's one of the more important conditions, and this just creates a positive obligation on persons to ensure the integrity and confidentiality of any information that they process and protect, store on their database or in their offices. And what some of the questions I got was, well, how am I going to do that? So what the Act, it doesn't state how you have to protect information or secure it. It just states that you must. So as long as the person that is processing the information is satisfied with information kept on record, is secure, whether it be on cloud storage or otherwise, then that is all that they are required to do in terms of this condition. Further questions that I got was, how do trustees protect themselves regarding CCTV footage within a scheme? What security measures must be put in place? So what I mentioned was that, CCTV falls under the definition of personal information. Thus, when processing footage, one needs to comply with these 8 conditions, including the security of the information. So as long as the body corporate is satisfied that the information is being kept secure, then they are complying with this condition. The last condition being participation. So this is loosely, a person will always have the right to ask whether someone holds the information, request copies of what they are holding of theirs, and the details of all third parties who have or have had access to the information. The question I got was, how can scheme executives know that they have met the requirements of this extensive legislation? And, my answer is that as long as you're complying with these 8 conditions, then you have met the requirements of the Act.
Yeah, I just want to touch on an interesting point, especially with managing agents and with their data, where their data is stored, when you refer to the cloud storage.
Yeah.
In terms of Section 72 of the Act, POPI Act, if your cloud is based outside the Republic, you need to inform the persons, the data subjects as well. So that's a further obligation upon the responsible party when it comes to openness. So the Act clearly states you need to inform them, and where the data is, you must ensure that in that republic where your data is stored, they are compliant with POPI. Otherwise, you can't store your data there.
Yeah.
So for instance, we use Azure with Microsoft, and with their data protection policy, that complies with our POPI legislation. So we will be able to do that. So just as a cautionary note, you need to look at where your data is stored as well.
Yeah.
Leigh-Anne, just a point on one of your last comments that you made as well, as we and I know get a lot of questions from people. Does this now mean we can't install a security camera within our estate? Do we have to remove the security cameras that we already have? Where can these security cameras point? What processes need to be complied with? And then, of course, with the footage of it, well, does that now become something that people can't access? I know you recently dealt with a question where somebody asked what happens if they need that footage for the purpose of proving that a crime was committed. That's an interesting point to mention as well.
Yeah, I think we discussed it this morning. So, if there's footage that an owner requires because a crime was committed, it must be supplied to the South African Police Service. And what I mentioned was that whenever you are processing personal information, sharing it in this instance, always look at what your lawful basis is in this case. And when there is a crime that's committed, you have a duty to report it to SAPS. And in this way, that's your lawful basis. You require the footage so that it can be submitted to SAPS so they can investigate and attend to that investigation. There's your lawful basis for the sharing of the footage. And then you are complying with the requirements of the Act.
Should SAPS not have a warrant to get it?
Look, I'm not well versed in the South African Police Services Act. So most likely there are requirements when it comes to that. And when someone is requested by SAPS to provide information, then it's best to just get your ducks in a row and consult with someone if you are unsure.
Okay. Thanks, guys. Rudi, I think we're running out of time. I mean,
yes.
But let's quickly have a look, because we also had a lot of questions, and we have touched on it, on the information officers.
Yes.
And also the deputy information officers. Can we quickly go through that?
Yeah,
again?
so I already started what I refer to as the head of institution needs to be the information officer. Otherwise, it's a person duly authorized by such person. So we don't have to go into detail through this. I'm sure that these slides will be made available, so everybody can go through it. But in a nutshell is what I mentioned previously. Just the one thing that I want to add to what I stated previously, the information officer must be registered. There's a form that you need to complete and send it. If you appoint a deputy information officer, such a deputy needs to be registered with the regulator as well, and his duties as well. Because what the regulator actually wants is, if there's a data breach, they want to go to the relevant person and ask that person. It's your responsibility, deputy, in terms of this, to secure against data breaches. If there is, you understand, so they want actually, you need to spell out the duties. And if there's a change, you also need to inform the regulator. So you constantly need to update your information with the regulator. So we don't have to go into detail with that. And just loosely, the duties of the deputy and the information officer is to comply with POPI and Pyre. That's the long and the short. So if Leigh-Anne just went through all the principles of the Act, and that's in short what the information officer needs to do. It's also defined in the Act, but you need to apply the principles as mentioned.
Perfect. The consequences, if you don't do this, what happens?
Go to jail. Yes, so what the Act says is a penalty or a fine not exceeding 10 million. It's 12 months imprisonment. So we assume it would be either the information officer, well, it will be the head of the institution, because you can't get rid of that. And there might be a damages claim as well. So why they included this damages claim is very interesting. When there was this security breach of Experian during December of last year, everybody thought, okay, they're going to be free because there's no fines applicable. No, it is not. You still have your common law right to institute action, and what they actually just did is say there's still a damages claim, but they could have been sued previously as well. So, but that's the long and the short. Or further, we've seen that they want to refer to an infringement per infringement fine. They're talking about 3,000 rand per infringement. And as I understand what they're suggesting, if you share an email per se containing somebody's name, telephone number, ID number, and banking details, and you share that with somebody, that is actually 4 infringements, which can relate to a 12,000 rand fine. But we still need clarity on that point. So we'll know by the 1st of July exactly what the fine system will be.
We also, prior to everybody joining, had a chat about this penalty not exceeding 10 million rand and the huge risk that this places on schemes. And I just want to say that we were all of the opinion that that would not happen. I mean, we can't see that the legislator will impose these kind of fines, well, initially to start off with, but eventually also on schemes. We can't really see that. Leigh-Anne, what was I think that was your take as well, eh?
Yeah, I don't see, a smaller scheme as opposed to a bigger scheme being with a hefty fine being imposed, but it also leaves, much to be. We're waiting on what should happen in the next 2 or 3 or 4 months. We can speculate, but Rudi made a good point that a company like Google, if they've got a breach and they get fined 10 million, that's school fees for them. They can pay it and move along. But for a smaller scheme or any scheme of however many units, I can't see them, initiating a fine of such a high amount. 3,000 per infringement seems reasonable. So then we wait and see what will happen. I think a lot of case studies will be created when the time comes, when these things start happening.
Well, yeah, I also think the fine will be dictated by the budget of the regulator, because they need to pay salaries and so forth. So if the budget is low, we'll receive higher fines. So
Yeah.
let's just have a look at the budget.
Yeah.
Okay, guys, information regulator. We had some questions about that as well. Rudy, can you tell us what's the situation there? Have we going to have
so the information regulator has been established, and the responsibility is to provide education, to monitor and enforce compliance, to consult with interested party and handle compliance. So it's similar to CSOS. We all know CSOS. If there's a complaint, you phone them. If you want guidance, you can phone them. So it's similar to the Ombuds service as we know it in community schemes, and that is the role of the information regulator. If there's a breach, you must inform them. They will be, I like to refer in my webinars to them as the POPI police.
Okay. Leigh-Anne, where do we start? We're running out of time, but let's see where we can start.
So I'd just like to highlight that TVDM Consultants will be hosting a webinar tomorrow, and this exact question is being asked. How do we practically apply the Papia, and what steps do we need to take? So Zerlinda has sent out the invitation to the people who have registered once more. So perhaps that can be shared after this webinar as well. But it really is about creating, the compliance framework manuals, registering your information officer, and your Pyre manual, and doing the next. And there's a few requirements. So I'll be touching on that tomorrow. And if you are available, please do join us.
Perfect. WhatsApp, Facebook, CCTV cameras, lots of questions about that. Can we quickly, Zerlinda, quickly go through those? WhatsApp groups in community schemes, how does that get affected?
So, there's also been questions that we've received about whether or not WhatsApp groups now need to be closed down, whether they have to only have an admin function, whether Facebook groups or similar portals need to be shut down. And those are also allowed. You're completely allowed or permitted to have these under the legislation. You just need to have the person's consent before you add them to the group. So, you can't simply say, just add this person because they're a new member. You have to get their written consent to be able to add them. And very often, you would also need to determine whether or not the person that is getting added is a registered owner versus an occupier or a tenant, and whether or not their consent is given. And if you're going to share something on that group, is it something that the tenant or the occupier might necessarily need or not need access to? So perhaps in a sectional title scheme or an HA, you could have a WhatsApp group for trustees, you could have a WhatsApp group for owners, you could have a WhatsApp group for residents. And then again, it needs to be utilized for a specific purpose as well. In my homeowners association, we've got two. We've got one for like general chat and general admin, and then we've got one for security reasons. And there's different people that are on those two WhatsApp groups. When it comes to, having that information stored, having it destroyed, again, if the person is no longer a member, if they're no longer an occupier or a tenant, that information should be taken off. So the administrator that is dealing with it obviously needs to be au fait with who those people are or not. And then I think you mentioned, access control systems and footage of CCTVs and all those things as well. Again, nobody can refuse to, give their IDs over, or to have, like you mentioned, biometrics or facial recognition that we spoke about before the session started. It all again comes down to security in regards to its storage, the processing, destruction when the person is no longer an occupier or a tenant. But we did touch on all of that a bit earlier in the session.
Yeah. There was just one interesting question. Sorry, the biometrics that they say is maybe more POPI friendly than paper access control, but now not so COVID friendly. We were not so sure that that is actually true, hey?
No. I don't think so. But yeah, again, when we look at access controlled entrances, you can put up a notice to say you won't enter this scheme without providing us with this information. That is lawful to say that. And you can say to the people, we asking these information, we processing this information for a legitimate interest, being for security reasons. So one cannot go to an estate, demand entrance, but however call upon the POPI card not to provide the information. So that's going to be difficult. So it is lawful in that sense. The company, I just want to add, the company actually then rendering this service, the POPI Act then applies to them how they process and hold this information. So it's not per se the scheme's problem, it is then the service provider, because everybody that processes information falls within the ambit of the Act, and they will have to do this. I just want to touch on, sorry, Willie, I'm interrupting you, on the WhatsApp groups. As I've mentioned previously, be careful of secondary processing of personal information. If we look at the Act, in specific reference to the Sexual Title Schemes Management Act, you need to, the body corporate must retain certain personal information, which includes the telephone numbers. Now, what the management rules does not say is to create a WhatsApp group. So if you take all the numbers and you want to create this WhatsApp group, just apply caution. As I said, rather get the consent, inform the members if they want to join, send out a link or something, let them join. But don't just add them to a group, because in the strict interpretation of the Act, you might be in contravention of POPI.
Perfect. Exemptions.
Nothing.
Are there any?
No.
That's the simple answer, eh?
Yes,
You don't have to make a long thing about it.
Yeah, we can debate and say how irritated we are that there is no exemption, but as we speak, there's no exemptions. Everybody needs to comply with POPI. Hopefully in future, they're going to get the Act together and actually look at different industries and apply different rules to different industries. Because what they're doing is they're putting a community scheme with 3 units in the same boat as a company like Experian, TransUnion, Standard Bank, ABSA, because everything applies to all. So that's the issue that I have with the legislature. But as we know, we went through COVID and they had to enforce and get everybody POPI compliant. So I think that is the reason why everybody is in the same boat, and perhaps in the near future, there will be different rules for different industries.
Thanks, guys. We're already over the time, but it doesn't matter. I think people want to hear these things. So thank you all for partaking in this. Zerlinda has posted that link on the questions section. So guys, you can click on that and register for that session tomorrow to get some more information on that. And thanks for everybody for the participation and the information that you guys have shared. I mean, it is important that we get these things sorted out. Regarding the questions, we will go through them, the ones that have not been answered, and we will try and answer that, and we will also then put that as a link that everybody can click on and get those answers. I think that would be the way to do it, and I think Daniela will also then share those 2 manuals or 2 documents that we have drawn, the free resources.
Yeah, we'll share that over the next day or 2, as well as the recording of this webinar. So thank you, everyone.
Yeah,
thanks, guys.